Welcome back to Winning Isn't Easy. Appealing denials and maximizing your SJS claim. I've alluded to and touched on a little bit about the any occupation game. Now, carriers rarely want to pay benefits beyond 2 years. At the any occupation stage, they'll assess whether you can perform other work, generally in the national economy, regardless of whether you could actually obtain such a job, or sometimes regardless of the wages that it pays. Education, your education background, the skills that you've learned in other work, and your age are going to be reviewed as factors. But I will tell you that age is given minimal weight, if at all. Now, what's going to happen is that the carrier is going to use a vocational expert to first determine what your past occupation was, the strength level at which it was performed, and the skills that you would have learned by virtue of that occupation. Then, generally applying the carrier or plan's doctor's opinion about your restrictions and limitations are going to determine whether you have the skills that you have would transfer to other work. And most likely, they are going to be looking for sedentary work, which is basically sitting 6 out of 8 hours, standing basically 2 to 4 out of 8, lifting no more than 10 pounds with bilateral manual dexterity and meeting pace and production requirements. So what they're doing is they're looking at their doctor's opinions about restrictions and limitations, determining whether there are any transferable skills, and if not, what other occupations you might be able to do. And if there are transferable skills, then what skills you could take to other occupations. They're then going to try to see if they can come up with a match. And that match will be the basis of the denial. And they'll say, well, we believe that you're capable of engaging in any occupation based on the restrictions or limitations of our Dr. Liar for Hire. And our Liar for Hire VE has opined that you're capable of doing the following occupations. Again, based on the terms of the policy or the plan as any occupation is defined. And that is going to lead to a claims denial or termination. Now, what's important as a starter here is medical documentation. You have to give your doctor a full picture of your limitations, including your symptoms, the frequency of your symptoms, how those symptoms impact your function, the pain level you have, your response to treatment, the side effects of medication, and by body system problems that you have. Visual limitations such as blurry vision, light sensitivity, respiratory problems such as shortness of breath, having to use oxygen, and other body system involvements. Ultimately, your doctor needs to understand how these body system symptoms impact your ability to walk, sit, stand, lift, carry, and bend. I think the medical records need to tell the story of your day-to-day challenges and a history of your symptoms and functionality, with you giving that interval history to the doctor between, what your symptoms were between visits. I will tell you that vague records harm your credibility and the success of your claim. That's not all. Let's talk about the residual functional capacity form. I've told you in the earlier segments that the carrier is going to use their own attending physician statement forms that purposely don't ask the right questions because they don't want the right answers. Social Security lawyers such as myself have prepared detailed RFC forms, such as pulmonary forms, visual impairment forms, gastroenterological forms regarding skin impairment. We use those in our practice as a supplement to the attending physician statement form. And by the way, generally, we're also handling the Social Security disability claim. But the RFC form can help document, for example, how far you can walk, how long you can sit. Do you need to alternate sitting and standing? Do you have problems with the need to elevate your legs or to avoid sunlight or the need to take frequent breaks? It can address visual and respiratory restrictions. It can discuss the impact that your symptoms have on your ability to concentrate or maintain pace and production or absenteeism. All of these factors are really not just factors, but they're details that paint a true picture of your limitations and make it harder for the insurance company to deny your claim on on the basis of incomplete evidence. Now, I find that it's important that you have a disability attorney that helps you with the SJS claim, particularly at the any occupation stage. Many times what happens is that the carriers or plans will argue that you recovered enough to perform other jobs in the national economy, but they're going to overlook critical complications like the ongoing visual impairment that prevents computer or screen-based work, respiratory limitations that make even light physical activity unsafe and difficult to perform, chronic fatigue, pain, and cognitive difficulties that interfere with consistent job performance. They'll also potentially address the skin impairment, which can impact bilateral manual dexterity, impact your ability to sit, impact the use of your feet, impact the use of your upper arms, the kinds of things that would make it difficult to do a sedentary job where you're sitting down all day. If you find yourself in a situation where your claim has been denied, I want you to understand that under ERISA, you'll only have 180 days in which to file an appeal. And the appeal is the trial of the case. What happens here is you should obviously be represented, but the representative is going to get the claims file and take it apart. Now, claims files can be 300 pages to a couple thousand pages. In our practice, we basically analyze those medical records. We're looking for those liar for hire opinions that the carrier got to justify the claims denial because we want to attack those. We also want to see what the policy or plan has to say because here we are starting to build a comprehensive appeal, a detailed appeal that's filled with medical evidence, legal arguments, expert reports, statements from you, probably photographs. We also want to get residual functional capacity forms from your doctors, and if possible and appropriate, get a functional capacity evaluation that will measure and establish why you can't even do a sedentary job or the dumb jobs and that the liar for hire vocational evaluator for the carrier said you could do. And then lastly, we want to tie this up together with a vocational analysis. They had a vocational quote unquote justification for denying your claim on the basis that you could do any occupation. Well, we need to rebut that. So many times we will hire a vocational expert to address the occupations that the VE says that you could allegedly perform and show that your real world limitations prevent substantial employment. You have to understand that there's deadline management here because you only have 180 days in which to file an appeal. And if you don't, you will have most likely lost your rights to file a suit because you haven't exhausted your remedies. It's really crucial that that appeal be filed timely and that be monitored because under the ERISA statute, carrier has 245 days in which to decide the case. If they don't give a good reason after the first 45 days, a lawsuit can be filed and filed quickly that will impact the standard of review that the court uses. The standard of review is really crucial in an ERISA case. And two standards of reviews are what's called the arbitrary and capricious, which is not arbitrary and not capricious, but it is a handcuff on the federal judge who has to have very circuit-specific reasons for overturning the claim denial. It's not just enough that they disagree with it. The judges have to meet certain legal standards and criteria for deciding that they are not going to defer to the denial. The other review is called de novo review, and that's the kind of review you want, where the judge is not bound by the carrier's denial or termination. They get to apply an independent opinion. However, you need to understand that the judge is only going to review what's in that carrier file, and the appeal is really a crucial part of the process in getting you the long-term disability benefits you deserve for SJS. You can see that SJS is a complicated disease with multi-system involvement. Carriers don't understand it. Claims are routinely denied, and you can prevent that by following the tips that I have given you in this podcast. So I hope you've enjoyed this important conversation about SJS. And it's more than just a short-term medical emergency. It leads to lasting system involvement that impacts your vision, your breathing, your mobility, your ability to work. And carriers generally don't see the whole picture. They're going to minimize your symptoms, misclassify your job duties, wrongfully assume that you've recovered. And that's not what happens. So I thank you for tuning in to today's episode of Winning Isn't Easy. If you found this episode helpful, please take a moment to like our page, leave a review, share it with your family or friends, and subscribe to this podcast. Join us next week for another insightful discussion and episode of Winning Isn't Easy. Thanks for listening.